Capital assets receive favorable tax treatment under the Internal Revenue Code. The code defines a capital asset in Section 1221 as property held by the taxpayer. However, this section excludes property held primarily for sale in the taxpayer's ordinary course of business. In Mauldin v. Commissioner, a taxpayer whose cattle grazing business was butchered milked the Internal Revenue Service to treat his subsequent land sales as capital gains. In 1920, C.E. Mauldin contracted to purchase 160 acres of land. At the time, Mauldin intended to use the land as pasture for cattle grazing. However, by the time the sale closed, he had changed his mind, partly because the cattle business was no longer profitable. In 1924, Mauldin attempted and failed to sell the land. To facilitate its sale, Mauldin subdivided the land. In 1939 and 1940, Mauldin sold a substantial number of lots by listing the property with real estate agents and advertising the lots throughout town. After 1940, Mauldin stopped actively advertising the lots because he'd entered the lumber business and intended to hold on to the remaining land for investment purposes. However, Mauldin's land was in high demand, and he continued to sell lots. By 1945, Mauldin had sold most of the lots and only had 20 acres remaining. A large portion of Mauldin's income between 1940 and 45 was attributable to the sale of lots. On his 1944 and 45 income tax returns, Mauldin characterized the lots as capital assets and treated the profits from their sale as capital gains. The Commissioner of the Internal Revenue Service disallowed this characterization and treated Mauldin's profits as ordinary income. The tax court sustained the Commissioner's ruling. Mauldin appealed to the 10th Circuit.